Good afternoon, everyone. Thanks so much for joining us for the very first, the inaugural webinar in Denton's Labor Spotlight series, which is a new series that we'll be running, we'll tell you about shortly, focused exclusively on labor. I'm a partner here in the Denton's Toronto Labor and Employment Group, and I'm here with my good colleague, Emily Kroboth, who will be, you'll be hearing from in a few minutes on our first topic. But before I turn the mic over to Emily, I wanted to provide a quick intro to this new resource that we're hoping you will all find useful. As mentioned, this is the first webinar in the Spotlight series that focuses exclusively on labor relations as opposed to labor and employment. The goal of the series is to provide regular updates to you on topical issues in labor that are going to be more practical than strictly academic. So we're hoping that this becomes a resource that you can use day to day. At present, we're planning to offer a webinar every quarter, and we'll also be putting out articles on a quarterly basis as well, but offset. So every few months, there'll be some new content for you. You can visit the Labor Spotlight series page on the Dentons website, and there you'll find all the articles, recorded webinars, signups for upcoming content, and also info on what we're planning for in terms of topics for future webinars. To find that page, I'm sure there'll be links that you have access to that we'll be sending you, but you can also just Google Denton's Labor Spotlight series, and it should be the first hit that comes up. At present, you can access that site and read an article written by Emily and I on electronic surveillance, which is a companion piece for this webinar. Some of the articles will be going like that with the webinars, so hand in hand, and others will just be on topics as they come up that we feel would be helpful for you to read about. And that resource we expect to grow in time and over time. We hope you visit it frequently. And yeah, we're excited to offer it to you. So with that said, let's look at the agenda for this session. So first, we're going to turn it over to Emily, and she'll talk about employee privacy and surveillance in unionized workplaces. Then I'll take over and talk about bargaining trends in 2022. And then we'll have some time at the end for questions and answers. So now we'll turn it over to Emily to talk about the first topic.
Great. Thanks so much, Russ, for that excellent introduction. So hello, everyone. I hope everyone's having a good day. As mentioned earlier, my name is Emily Kroboth, and I'm an associate with Dentons Toronto Employment and Labor Group. So today I'll be unpacking the pretty live issue of employee monitoring and privacy in unionized workplaces. As the workplace becomes more and more digital, management now more than ever has the ability to monitor employees, whether through their computers or with the use of GPS technology, through employee cell phones, or through the use of video footage. This has resulted in arbitrators considering the delicate balance between management's right to monitor and run their workplace and employees' expectations of privacy. So moving to the next slide, today we'll be discussing three primary things that impact employee privacy in unionized workplaces. The first being the recent changes that Bill 88 brought to the Employment Standards Act with the addition of section 41.1.1, just to get very granular there, requiring most employers to implement a policy with respect to electronic monitoring. We'll also be discussing how the terms contained in the collective agreement can impact employee privacy, as well as the body of arbitral case law available to us, addressing the balance between management's right to manage their workplace and employee privacy rights. So next slide, please. So what is Bill 88? Bill 88, which amended the Employment Standards Act, is the most recent change in provincial privacy law with respect to employment. So Ontario does not have its own privacy regime applicable to employees like British Columbia and Alberta, at least not yet. So this amendment offers new protections. The bill introduced a new section of the Employment Standards Act, which requires employers with 25 or more employees as of January 1st to have a written policy on electronic monitoring and to provide a copy of this policy to their employees. Anyone who meets the definition of employee under the ESA is counted for the 25-person threshold, including probationary employees, employees on a definite term contract, and employees who are on leave of absence or on layoff. The policy also must apply to all employees, even those who are maybe exempt from other portions of the ESA, such as hours of work or overtime. So moving to the next slide. So what does this policy actually need to say? The policy needs to contain some required information, including whether the employer electronically monitors employees or not, a description of how and in what circumstances the employer electronically monitors employees, the purpose for which information obtained via the electronic monitoring will be used, and also the date that the policy was prepared. Next slide, please. So currently, there is no definition of electronic monitoring. However, the Ontario government has provided employers with some examples as to what is considered electronic monitoring. So for example, using GPS to track the movement of an employee's delivery vehicle is considered electronic monitoring. Using an electronic sensor to track how quickly an employee scans items at a grocery store checkout is considered electronic monitoring. And tracking the websites that an employee visits during working hours is also considered electronic monitoring. As mentioned previously, if you as an employer do not electronically monitor employees in any way, then the policy should specifically state this as well. The Ontario government has been clear that Bill 88 and the subsequent addition of Section 41.1.1 does not establish a right for employees not to be electronically monitored by their employer, nor does it create any sort of new privacy rights for employees. It just requires the disclosure of any electronic monitoring activity. So in sum, employers aren't barred from electronically monitoring their employees. They must simply disclose any methods they are using to electronically monitor employees. And just as a reminder, because it's coming up quickly, employers are required to have this policy in place by October 11th, 2022. So in just a couple weeks. Next slide, please. So the second potential source of privacy rights for employees or management rights of employers we'll be discussing today is the terms of the collective agreement. This is the first place management should be looking in order to determine what, if any, privacy rights employees have. And this also raises the question, given the introduction of Bill 88 and the subsequent amendments to the Employment Standards Act, which methods of electronic monitoring are included within standard management rights. So Ontario arbitrators have recognized a common law right to privacy in the workplace, meaning that a right to privacy may be read into the collective agreement. However, electronic monitoring may also be included within a standard management rights clause or within a more specific clause addressing employee privacy head-on. So with the introduction of the requirement for an electronic monitoring policy in Ontario, this makes the addition of clear language with respect to privacy and electronic monitoring in the collective agreement even more important, as this may help resolve issues prior to a union seeking grievance arbitration based on perhaps the electronic monitoring disclosed in this new policy. This is something to think about the next time that you're renegotiating your collective agreement. And although there are limitations on when employees can file a complaint with the Ministry of Labor, for example, unions may use the information disclosed in this new policy to file a grievance with the board. However, in this next section, we'll give you an overview of established privacy principles, which may assist you in determining if your current electronic monitoring practices may be upheld by an arbitrator. Next slide, please. So the third source of privacy rights for employees and rights of management is the body of arbitral case law available to us. So management holds the traditional right to manage the organization and to direct their workforce. Traditionally, management is free to do as it sees fit, subject to any express terms otherwise or any legal constraints. This is also the case when it comes to the use of surveillance technology. So when faced with a grievance pertaining to privacy, arbitrators consider established principles such as reasonableness, proportionality, and the balance of interests between the union and the employer. When an employer unilaterally introduces a new practice or rule to the workplace, such as the use of surveillance technology, the employer will be expected to establish that the surveillance technology is not inconsistent with the collective agreement, that the surveillance technology, the use of it is not unreasonable. The use of surveillance technology is clear and unequivocal. The surveillance technology is brought to the attention of employees affected before the company acts on it. The employees concerned must have been notified that a breach of a rule or policy determined through surveillance technology could result in discharge. If so, and the rules around surveillance technology should have been consistently enforced by the company from the time it was introduced. So traditionally, when assessing issues related to privacy rights, arbitrators have found that there is a spectrum of invasiveness or intrusion on privacy rights, as well as a hierarchy of protection afforded to different privacy interests. The strongest form of employee privacy being with respect to bodily integrity, the second being searches involving an employee's personal effects and spaces, and the third level relating to surveillance, within which there is a range from overt surveillance to covert or surreptitious surveillance. Arbitrators have had many opportunities to consider employees' privacy rights, in particular with respect to searches of a worker's person and personal property, medical privacy, such as drug and alcohol testing, vaccination, provision of medical information, virus testing, polygraph testing, fingerprinting and scanning, as well as criminal records checks, electronic surveillance devices, as well as security checks. So with respect to searches of a worker's person and personal property, arbitrators have found that this is not generally permitted unless the collective agreement allows it, or it is an implied term of employment. When such searches are permitted, arbitrators apply the balance of interest tests, weighing the need for searches against the severity of the privacy intrusion it presents to the employee. With respect to medical privacy, arbitrators generally apply the same balance of interest tests. And in terms of electronic surveillance devices, arbitrators will ask, how are they deployed? What is the purpose of such devices? Arbitrators have drawn a distinction between overt, so obvious, clear surveillance, and covert or hidden surveillance. Where covert surveillance is used, arbitrators generally inquire as to whether or not less intrusive measures may be used, while the use of overt surveillance is based on whether such use is reasonable in the circumstances. In certain cases, arbitrators have allowed the use of cameras in the workplace in order to deter theft, and allowed the use of geolocation devices to prevent time theft. Arbitrators have also allowed overt surveillance devices for the purposes of keeping the workplace safe. And finally, with respect to security checks, these have been found to violate employees' privacy in the absence of a real threat present in the workplace. Next slide, please. So looking to the arbitral case law, employers are generally permitted to do the following: inspect employees' lockers and parcels. For example, in one Ontario case, an arbitrator found that the introduction of random parcel and outer clothing searches was reasonable in the face of a large employee theft ring that operated within the employer's warehouse. Many of the employer's goods were small and easily concealed, making it easy to take the goods out of the workplace without authorization. Monitor odometer readings in company vehicles has also been permitted. So in a British Columbia case, where the employees used a company vehicle to go from site to site. An arbitrator found that the use of telematics devices to monitor whether employees were using company vehicles for business or personal use was simply managing the employment relationship. Note, however, as I mentioned earlier, that privacy grievances, the analysis differ in different jurisdictions that have their own privacy legislation, such as British Columbia and Alberta. Ontario does not have privacy legislation applicable to the private sector, so the analysis in each jurisdiction will differ slightly depending on that province's established privacy regime. Arbitrators have also allowed the use of CCTV cameras for the purposes of surveillance, where employees have full knowledge of such cameras. So for example, in one British Columbia case, the arbitrator determined that surveillance of a production area was reasonable through using a balance of interests and proportionality analysis. The arbitrator found that the reasonable implementation and installation of cameras addressing a real safety and security issue was permitted. However, as video monitoring moves from the use of CCTV to cloud-based video monitoring, employers must be mindful of how long information is stored in the cloud and of any required security measures to implement in order to prevent unauthorized access to this footage stored in the cloud. These factors will go toward whether or not the use of cloud-based video is reasonable in the circumstances, weighing the employer's management interests against the employee's privacy interests. Arbitrators have also generally permitted scrutinizing its email system and its use by employees. So in a 2003 federal grievance, an arbitrator found that the employer's decision to audit its email systems following a complaint that employees were sending sexual content to one another via the employer's computer systems was reasonable. The arbitrator found that employees had been given several warnings, and there is no reasonable expectation of privacy in email communications sent at work. The invasion of privacy in this case was considered minimally invasive and not comparable to something like urine analysis or personal property searches. Arbitrators have also generally permitted contacting third-party employers. In one recent Ontario case, the union fought a griever's termination for sick leave fraud, partially on the basis that the employer's choice to contact the griever's second employer was an invasion of privacy. The arbitrator found that contacting a griever's second employer was minimally invasive, and any breach of the griever's privacy in this case was de minimis. The arbitrator ultimately found that the employer was entitled to terminate the griever's employment on the basis of sick leave fraud. So in all of these examples, and in all of these situations, arbitrators are more likely to permit the use of various surveillance techniques where the invasion of privacy was relatively insignificant. Next slide, please. So the most significant and recent case on the subject of electronic monitoring in the workplace is IUOE Local 793 and earth boring. In this case, the union brought a grievance challenging the employer's introduction of third-party software called ExactTime, claiming that it was an enforcement of unreasonable management rights and a violation of employee privacy interests. The union requested that the employer immediately cease and desist use of the software. The purpose of the software was to take the place of paper timesheets and records and to accurately capture when employees arrived to and left the worksite. ExactTime software required employees to download a mobile phone application onto their personal cell phones. Employees were then expected to use the app to clock in and clock out by taking a photo of themselves on site and uploading it to ExactTime, which indicated the time and the geolocation at the time the employee clocked in and out. Next slide. So the union was concerned about the use of the ExactTime software because the ExactTime app made use of a geofence, which allowed the employer to track the movements of employees within the specific boundaries of a work site. The union was concerned about the app's ability to track employees even when outside of the geofence. The union was also concerned that data uploaded to ExactTime was retained by the employer indefinitely, and data uploaded to ExactTime was stored on cloud servers, not the employer's own servers, and shared with third parties such as Google Analytics. Next slide. So the employer wanted to use the software in the first place to prevent the practice of buddy punching, whereby an employee punches in another employee's time card, for example, when they're running late. And this, of course, results in time theft. The employer in this case also argued that the use of ExactTime significantly reduced its administration costs by hundreds of thousands of dollars because they no longer had to go through the hassle of using paper timesheets. Next slide. So in order to determine whether to permit the employer to continue using ExactTime, the arbitrator applied the balance of interests test established in the Supreme Court decision Irving Pulp and Paper. The arbitrator quoted the Supreme Court in his decision stating, "Determining reasonableness requires labor arbitrators to apply their labor relations expertise, consider all of the surrounding circumstances, and determine whether the employer's policy strikes a reasonable balance. Assessing the reasonableness of an employer's policy can include assessing such things as the nature of the employer's interests, any less intrusive means available to address the employer's concern, as well as the policy's impact on employees." Simply put, the arbitrator found that if employers want to intrude on the privacy interests of employees, they must be able to provide a good reason to do so. Next slide. So regarding the law that the arbitrator considered and the appropriate balance of interests, the arbitrator relied on the following principles. An employer must demonstrate the presence of real security issues with appropriate evidence before implementing electronic monitoring or surveillance software. Security measures such as two-factor authentication and encryption of data in transit and in storage may reduce the severity of a software technology's intrusion into employee privacy. The length of time for which data is stored may either reduce or increase a software technology's intrusion into employee privacy, and whether or not the data is shared with third parties or stored by third parties may factor into how intrusive the technology is determined to be. Next slide. So in this case, the arbitrator ultimately found in favor of the union. At arbitration, the employer could not present any evidence of buddy punching occurring in the workplace, so they weren't able to establish a problem that needed to be addressed. As a result, the employer was ordered to halt the use of ExactTime in its current form and ordered the employer to request that ExactTime destroy all of the employer data that it had stored. The arbitrator was not swayed that the employer actually had a problem that needed to be addressed due to the lack of evidence presented at arbitration, and had serious concerns about ExactTime retaining employee data, including facial images, for an indefinite period of time. The arbitrator also had concerns about storing data on third-party servers, sharing data with third parties, and tracking employees' location outside of working hours. Ultimately, the arbitrator found that the balance of interests lay in the union's favor because the little to no evidence of buddy punching did not outweigh the employee's expectation of privacy. Had the employer in this case been able to present any evidence of buddy punching, the arbitrator may have reached a different conclusion. Next slide. So in a case called Agriper Division Natrel and Teamsters Local 647, this decision can be contrasted with that of the earth boring decision. In Agriper, the arbitrator found that just some evidence of buddy punching was good enough to justify the implementation of finger scanning technology in the workplace. In Agriper, the finger scanning technology was minimally intrusive, according to the arbitrator, because the scan only captured less than half a fingertip of data. The scan was converted into a template with the actual fingerprint data being immediately deleted, and the template data was stored on a secure server owned by the employer. The differences between this case and the earth boring case are quite broad, and employers should note in particular that only minimal evidence was required in the Agripur case due to the strength of the privacy and security measures implemented in tandem with the finger scanning technology. So in earth boring, the arbitrator found that the employer was not able to establish a problem that needed addressing. And the arbitrator also had very strong concerns about the particular technology that the employer was using. While in Agripur, the arbitrator was satisfied with just a little bit of evidence that the employer was able to present about the practice of buddy punching. And the arbitrator was also satisfied that the technology used by the employer had the appropriate safeguards and precautions in place in order to protect employee data and employee privacy interests. So just moving to the next slide. So just to wrap up this section of the webinar on privacy and electronic monitoring in the unionized workplace, we'd like to remind you of some high-level takeaways for today. So employers with 25 or more employees in Ontario require a policy with respect to electronic monitoring by October 11th, 2022. Before implementing any electronic monitoring or surveillance software, employers should review the collective bargaining agreement to determine if any sections pertain to or could arguably pertain to employee privacy or the use of surveillance technology in the workplace. Prior to investing in electronic monitoring or surveillance technology, employers should seek to understand the technology's data practices, such as how long data may be stored for, where data is stored, and what security measures are built into the technology. Employers should gather evidence of any workplace issue requiring the use of electronic monitoring or surveillance technology in the workplace, should the use of such technology be challenged by the union. And employers should seek a balance between mitigating a workplace issue and employee privacy, and seek out the least intrusive method to the issue at hand. So I'll now be handing things off to my colleague, Russell Groves, who will be discussing some recent trends in collective bargaining today.
Great, Emily, thanks. That was awesome, really interesting. So if you have questions related to electronic monitoring, please feel free to type them into the question box down at the bottom, and Emily can be looking at them and getting ready to give you some answers while I'm speaking. And of course, you can also put in questions relating to bargaining trends, which is what we're going to be talking about next. So we'll switch to the next slide. Not surprising, wages are the absolute #1 issue right now in bargaining. They're always important, of course, but right now, because of circumstances we're seeing in the economy, it's #1 with a bullet. Unions in the past, maybe even decade, have been pretty satisfied with 1 to 2% annual wage increases, particularly pre-COVID. But we're seeing now when we're at the bargaining table that the expectation is double or triple those percentages. And as I implied earlier, the explanation for that is obvious. Inflation's at a 30-year high, reaching 8.1% in Canada for June. And while inflation's eased off a bit in the last month or two, it's mainly due to low gas prices. So Canadians are still feeling a pinch, and union members, of course, with respect to things like groceries and home prices. So, well, maybe not home prices as much, but homes are still very expensive. So unions have that ammunition to bring to their members, to give them mandates for strike and to bargain hard with their employers. On the flip side, employers are facing another set of problems. Many of them have struggled during COVID, and times are not particularly great. Others are feeling a pinch themselves from inflation as the price of raw materials and labor increase. And many employers are also anticipating a recession kicking in Q1 or Q2 of 2023, which is causing many to feel that it's time to sort of tighten up and batten down. As a result, there's a pretty big misalignment between employers and unions shaping up, and we expect that there's going to be a lot more strike action and lockout in the next 12 months and possibly beyond. Of course, there's also the other perspective that many employers are feeling the pressure to increase wages to attract and retain talent. And certainly we're seeing this in the health sector where nurses are being lost at an exponential rate due to some of those issues. So the disconnect on wages might not be as great in terms of the importance of wage increases, but we anticipate that it'll still be a high conflict point in the next 12 months. So if we go to the next slide, we can see some trends, specific trends in terms of bargaining results. I think these are Ontario specific, but they're likely able to extrapolate to the rest of Canada, where you see wage increases in the public sector and private sector. And as you can see, the public sector wage increases remained relatively low. They did jump up a bit, but generally below 2%. And that was largely likely due to the passage of Bill 124 in Ontario in June of 2019, which capped wage increases from most of the public sector to 1%. In the private sector, we see another story. We see a big jump, particularly in Q2 of this year, to 4.4%, which is a doubling of what we've seen previously, which is not really a surprise. And if you switch to the next slide, we can see that trend over a longer period. So here's a decade of data, and you can see both public and private sector bouncing around between 1% and 2% annual wage increases, and then sharply spiking up as the CPI started to rise in 2021. With inflation likely to stay somewhat high in the near term, it's likely peaked, but it's likely not going to drop suddenly, given the state of the current strength of the American dollar, the current labor shortage, and the war in Ukraine. We expect that unions will still be using high inflation to rally support from their members for hard bargaining and strike mandates. Of course, if the economy tips into a recession in the next few months, employers will have a better argument to hold the line on wages. But as you can see, conditions are ripe for labor conflict in both the public and private sector right now. Look at the next slide. We can see a bit of a breakdown by industry for wage increases. And you can see, not surprisingly, construction's pretty high. Trade and finance as well is high. Manufacturing is there as well. And then you can see some of the public sector divisions there are much lower. Maybe go to the next slide, please. This is an interesting slide. There's not a lot of data here, but basically what we're looking at is the average duration of bargaining for the last 3 years in both the public and private sector. Sorry, this is just the private sector. And as you can see, most agreements are generally struck within 1 to 3 months. But that actually jumped up significantly in 2022. And it's a bit of a mystery of why that increase happened, but one of the reasons could be the use of Zoom and other virtual techniques for doing bargaining, which has actually taken off. And a lot of parties are finding that it's both more efficient and also less prone to lead to conflict that can be a roadblock in negotiating. So that might be one explanation. The other explanation might be that really things are coming down to dollars and cents more and more. So we are seeing deals made on wage proposals mainly. So there's not as much finicky argument over language right now. So that could be another reason why we're seeing deals happening a little quicker than in the past. But it'll be interesting to watch this in the coming months as more of the bargaining happens in the context of this high inflation. Let's go to the next slide. So this last chart shows just the number of work disruptions in the past 3 years. These could be strikes or lockouts in both the public and private sector. And looking at the private sector, at least, you can definitely see a trend to increase, specifically since 2022 is not yet over. So we'd anticipate if the trend continues, we'll have sort of that increase in 2022 and into the future. So to the next slide. So in general, some of the other trends beyond monetary we're seeing in bargaining right now is, like I mentioned earlier, an increasing willingness to use Teams or Zoom for virtual bargaining, which is quite successful. Unions are demanding more sick time being built into collective agreements. And employers are generally seeking more flexibility in terms of scheduling, work assignment, and layoff, so they can fill gaps in skill and person power as needed. And finally, we're also seeing unions pushing again for a cost of living adjustment, or COLA, which is kind of interesting because the last time that it was an issue in bargaining was over 30 years ago, which is leading to another problem that we're seeing, not at the bargaining table, but more in terms of grievance arbitration. So we're starting to see more grievances now where unions and employers are arguing over when a COLA provision in a collective agreement will be triggered. For example, is it if the CPI increases by a certain threshold at a certain month, or will that threshold need to be hit after a year on an annualized basis? So the problem is these terms, the COLA terms in these collective agreements, were bargained in the 80s and 90s and then never used because inflation quickly dropped. So this is the first time they're being used, and most of the employees that bargained or were even around with the company during that time to understand that language are no longer around. Now, normally that's not a problem because we shouldn't be relying on that kind of extrinsic evidence when we're interpreting a collective agreement, but these COLA provisions are quite complicated. So we're definitely recommending to employers that they take a look at any provision they're agreeing to or any current provision and really scrutinize it for how it can be interpreted and include examples on how calculations should be made and so on. We're certainly available to provide advice on that. So we hope that's a useful review of some of the trends that we've been seeing, and you can use those if you've got bargaining coming up in the near future. And we're certainly open for feedback on what other types of data would be useful for you in terms of bargaining trends. So feel free to reach out to provide that so we can circle back to it in future webinars, because we're hoping to make this section something consistent. So you can come to us, come to a webinar every quarter and get a little bit of an update on bargaining. So with that, I think we're ready to turn to some questions. Emily, did you want to?
Yep, I can get us started.
Sure, yeah.
I have a couple questions in front of me here that we've received. So one of which being, what happens if the number of employees I have in a given year changes throughout the year or below the 25 threshold? That is the requirement to have an electronic monitoring policy in place. Do I still need an electronic monitoring policy in that case? And the answer to that is the requirement to have a policy in place is determined by the number of employees you have on January 1st of each year. So if you have 25 employees on January 1st and that employee count goes down later in the year, then you'll be expected to keep that policy in place. If you have less than 25 employees on January 1st of a given year, and that number increases past 25 throughout the year, you don't need to implement a policy because the number was less than 25 on January 1st.
Great. Emily, I had a question when you were speaking. It was with respect to the distribution of the policy and how that should be done. Are there any best practices or tips?
Yeah, absolutely. So employees should be given a copy of the policy, of course, and within the virtual work environment, what does that mean? So employees should be emailed a copy of the policy, and they should also be given the opportunity to print it at work and make sure that they know that they can do that at the workplace.
I see one question here around Bill 124, which is the wage restraint legislation in the public sector here in Ontario, and whether or not it's the cost or the cause of lower wage increases in the public sector. So certainly I think that's likely the main cause, that and agreements that haven't come up for negotiation yet. And there's another question here about being creative to get around it. That's a tough one. It's very difficult to get around the way that legislation is written, but I do anticipate that there's likely to be a change in legislation on that point. I know the provincial government's been speaking about wage increases for teachers that are above 1%. So I think if they were going to be promising that, they're going to be having to change something there.
Okay. And I have another question to answer over here. So is Ontario going to develop a provincial privacy law regime like British Columbia, for example? So the answer to this is maybe. The Ontario Ministry of Government and Consumer Services published a white paper in 2021 outlining proposed privacy laws. However, the laws have not yet been introduced or passed, so it kind of remains to be seen. But what is clear is that the government is certainly considering this.
There's another question here around bargaining and how long we expect the effect of inflation to influence bargaining of wages. It's a great question. It's obviously a little bit of crystal ball, but I think because the prices going up, unions are going to have a good argument that any agreement in the next 1 to 3 years needs to have those increased costs built into it. So until that's normalized, even if we're bargaining, a year or two from now, it's possible that unions, unions will be relying on that historic inflation because prices are just going to be higher, even if they're not increasing as much or by the same rate.
Okay, and I have another question here about the electronic monitoring policy. So what if I have less than 25 employees in each of my locations? Do I need an electronic monitoring policy in that case? So the answer is yes, you do. All employees located in Ontario, not outside of Ontario, count towards that 25 threshold. So regardless of if those employees are spread out across multiple locations.
Okay, great. So we've got a couple ideas. If you have other feedback for us, please reach out. This is in its infancy, and we're hoping to turn into something that really grows into a helpful tool. So that wraps this first webinar up. Don't forget to visit the website, the Labor Spotlight Series site on the Dentons webpage, where, like I said, we have links to the articles, recording of this webinar, and there'll be new content coming up every month or so. And thank everyone for joining us. Have a good day.